nice to see everybody in their various states of home dress and storm gear. So let's get started. And I think, Cynthia, you'll start with the roll call.
Yes, thank you, Chairwoman Drum.
Thank you.
Good afternoon, everybody. Chairwoman Drum, you're there.
Yes.
Chris June Kiliani. Bevan Lister. Laura Fitzsimmons.
Here.
Rob Tellis.
Here.
Julie Kavanaugh Bill. Joni Easley. I saw her earlier. Joni Easley.
Cindy, you might want to tell everybody we're muted.
Hello,
Joni?
I'm here.
Oh, okay.
I'm here. Sorry, I was muted.
Okay. Lorinda Wichman.
I'm here.
Dave Mendiola.
I am here.
Jeff Wells.
Hello.
Hello. Drew Christensen.
I'm here.
Kate Thomas.
I'm here.
And Justice William Moppin.
Here.
I believe we have a quorum, Madam Chair.
Okay, that's great. And so I heard Chris G was not here, and there was one other person, Kevin.
Bevan Lister.
Bevan Lister. Okay, so we'll just keep our eyes open in case they are joining us. Great. Okay. So the first order of business is public comment. I do not believe that we have email comments ahead of the meeting, which is allowed. Is that correct?
That is correct.
Okay, so does anyone who's on the call wish to make a public comment before we proceed with the rest of the agenda? And just as a reminder, those are limited to 3 minutes. None? Okay, going. Great, thank you. So our first items are 3 and 4 to review minutes. So the reason we have 2 minutes is that we had our December meeting very soon after our November meeting, our November 20th meeting. So those minutes we didn't actually approve in December. So the first thing we need to do is approval of the November 20th minutes, which were posted and attached, I think, is the agenda. So any comments on the minutes?
Madam Chair, I thought they looked good. This is Joni Eastley. I'll make a motion to approve.
This is Chris G. I'll second.
I'll second that. This
Great.
is Laura. I have a couple corrections to the December minutes, but that's not what we're talking about,
That's
right?
coming next.
Got it.
Okay, so, and I just wanted to know that Chris G is obviously with us now, so that's good. So we have a motion, all in favor of approving the November 20th, 2020 minutes.
Aye.
Aye. Aye.
Any opposed? Okay, those are approved. Thank you. Okay, so let's go on to the December 2nd, 2020 minutes. Laura, if you want to make your comment now, and then we'll hear others.
I just have 2 comments. On page 19, when in kind of a third of the way down, Laura Fitzsimmons questioned how, anyhow, it was not Clark and Washoe counties, it was the rural counties. And then on page 32, the partial paragraph at the top ends indigenous services. It's just a typo. It should be indigent, I'm assuming.
Say that was again on 32.
Yeah, on 32, it says there's a partial, who's speaking? Hold on. It's Judge Schlegelmilch is speaking. It continues over to 32, and the final line at the top, it talks about to be a provider of indigenous services. I think it is meant to be indigent.
Yes. Is that it? for you?
That's it for me.
Okay, was there another comment? And I'm sorry, Dave Mendiola, I might have cut you off.
No, that's no problem, Madam Chair. I just going to tell you, Kate Thomas has joined as well.
I think Kate Thomas was, her role was taken initially, I believe. I think Bevan Lister is the only person on the board who's,
Yep.
we haven't registered. So I don't know if he's planning to join us, but we'll look out for him. Okay, any other comments on the December minutes? I assume there's no opposition to the correction. So can we have a motion to approve the minutes as corrected?
If there's no
This is
question,
Chris. I would-
motion to approve minutes of December 20th or December 2nd.
As corrected.
I'm going to interpret that over speaking as a second.
Yes.
Okay. All in favor of approving the December 20th, I'm sorry, December 2nd meeting minutes, please say aye.
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 Any opposed?
Madam Chair,
Okay.
Bevan Lister just joined the meeting.
Right. Okay, so I think there was approval and no opposition to the minutes, so those are approved from December 2nd. Welcome, Bevan. We are on number 5 on our agenda, which is presentation and discussion of proposed temporary regulations of the Board of Indigent Defense Services. And as you recall, this is, we had the workshop on, let me see, I think we had the workshop on our proposed regulations on December 2nd. Those are the minutes we just approved. We have, let me just ask, Marcy, am I supposed to be talking about this history now or when we approved number 6?
I believe that you can start it now before public comment.
Okay, so we're going to have public comment on those regulations. I wanted to give a brief history just to say where we've been, the process behind these regulations, so that we have it in our minutes. So basically, we have, the department was created in October 2019 with rulemaking authority. The board has been directed to create regulations as set forth in the statute, which is 180.320. We've discussed these at numerous meetings. I'm just going to itemize the dates, which is December 19th, 2019, January 29th, 2020, February 28th, 2020, June 29th, 2020, September 24th, 2020. The department, I think it was in September that we saw these, created a set of regulations. Those regulations reflect the 10 ABA principles on indigent defense. And you may have seen, did you post before the meeting, Marcy, the comparison?
No, we did not, but I can send it to all the members at this point. But we did a comparison of where our regulations lined up with those ABA standards or 10 principles.
Right. So that just maps out sort of where they fit in, and which is really helpful. And then we had our workshop on December 2nd, 2020. At the workshop, we obviously, the regulations were posted in advance of that to receive comment. We posted them on November 1st, 2021. And then we had some comments in advance because the department did a lot of outreach, which was extremely helpful, working with people in the indigent defense community to hear their concerns and sort of work them into the regulations, take account of them, some of which were then discussed at our workshop on December 2nd. So with that history, we now have before us regulations, which we can approve today because we've gone through the process that tees these up for approval. My understanding is that we did not receive emailed comments of the posted regulations ahead of this meeting, so none to discuss there. And now we want to open it up to the board as well as members of the public, and that includes members of the indigent defense community for comments today. So I think we can open it up to discussion. And then as those go along, we can also hear from the department if there are issues. So I'm opening it up for discussion. Okay.
Madam Chair, this is Bevan Lister.
Go ahead, Mr. Lister. Unfortunately, because of this interface, I appreciate your saying your name because you're not showing up with just as a speaker. So go ahead. I can't see you, but I can hear you. Oh, now I can hear you. And now I can see you. Great.
Yeah, for bandwidth reasons, I usually keep my camera off. So is there an anticipation that we're going to go through this page by page, or are we just taking comment and going?
Taking comments and going. And as I said, we didn't receive comments sort of in writing ahead of the meeting, but we have the opportunity now to discuss.
Okay, so I apologize for my being kind of late to the party, but I did notice a few things in my reading, and you're right, I probably should have emailed those in, but I'm presuming that these will then go through LCB for formatting and those kind of things. Is that correct? No?
I don't think so, but let me just turn to Marcy or to Daglong to explain. Marcy, do you want to handle this?
Yes, in talking with Sophia Long, and she can correct me if I am wrong, in the rulemaking manual, we are allowed to make temporary regulations. They do not need to go to LCB. So if they do pass today, within 35 days, they will be effective.
Okay.
And just to add to that, this is Daglong, just to add to that, if you decide to make them permanent, after July 1st of this year, you can start that process of making them permanent again.
And if my understanding is correct, as temporary regulations, they expire November 1, 2020. So we could start a permanent process as early as July, but we'd have to start it basically in the summer in order to replace these regulations come November. So in some ways, this is all kind of a pilot, right? This is a test run, which gives us, importantly, some flexibility to kind of work out issues as they arise if we need to kind of make some adjustments going forward before we have a set of permanent regulations.
Understood. And the reason I asked that is there's a few formatting things that I guess need to be looked at for consistency, but that's just a typographical thing. The couple of well, and they're probably not substantial changes, but sections 12 and 13, it would make more sense to me if that were under one section that related to that type of petition instead of two separate sections. And the same with sections 14, 15, 16, and 17, because they're both dealing with one certain kind of piece of what we want to happen. And so I thought that they should be a section of their own with the stipulations being in subsections. And again, that's a formatting thing, and not of great substance, but I just thought it worth mentioning. And then on those petitions, not the ones in sections 12 and 13, but in the petitions addressed in sections 14 through 17, is there an appeal process? How does the Administrative Procedures Act affected here? And that's just a pure question. You're talking to the dumb farmer on the corner, so that's just for what it's worth. And then the only other substantial question I had was in section 18, when we were talking about the costs, and it talks about the cost, so section 18, this is 1A2. The question that come into my mind is what year? Is it the current year of those consumer price indexes or union negotiated wages? And I guess it wasn't clear to me, and maybe it's clear to everybody else, and I'm just slow. So I'll leave it at that. Thank you.
So that's really helpful. Let me just kind of group them and then maybe we can take them in chunks. Does that make sense? So your first comment was basically, if I heard you correctly, was it focused on section 12 and 13 as being mostly a formatting comment? And similar formatting comment in terms of grouping 14 through 17. And then you had a substantive question on the appeals process and then a budget cost question. So I don't know who wants to take that, if Marcy or Jared, you're able to take those?
Yes, I believe that when we were discussing these at the workshop, we did point out that those sections are directly out of the Attorney General's administrative handbook on sections that need to be within your regulations. So we simply copied those directly out of the administrative handbook as we are told to do in creating these regulations. So the breaking them up in sections is set forth in that handbook.
All right, that's helpful.
And Marcy, that would cover everything up through section 17. His question about 18 is still a valid question because that's not part of the handbook.
Oh, and there's also just this question, do you understand the appeals process? Is there an appeals process? I think that was on 14.
It's on, I thought that was on the sections like 14 through 17.
Yeah.
And I actually joined the dumb farmer as the dumb lawyer in Carson City because I had the same question. But I think it comes into the ADA generally, right? At that point, once section 16 actually takes over and an opinion is issued, then the appellate, for Administrative Procedures Act takes over, I think, right?
That's my understanding.
And that's my understanding. I don't know if Sophia would like to chime in on that.
Yes, that's correct.
Okay. All right. And then Marcy or Jared, do you want to address the section 18 question about how the cost basis is formulated?
And generally, when we're building our budget, we have to build it for the next biennium. So we could put in, the, I don't know, language to reflect that current consumer price index. I don't know if anyone has any sort of options of what they would like to see in there, but we generally build the budget for the next biennium. So we'd probably have to use.
So it's the current, because it says in subsection 2, the consumer price index for all urban consumers West region is published by the Department of Labor for the immediately preceding calendar year.
Did you hear what Jared said, for the immediately preceding calendar year?
Okay.
Claire,
So for each budget year, then that's the number that would be applied.
Correct.
Yes.
So
Okay,
the lead-in sentence of section 18, paragraph 1, says during a fiscal year. So we start with that current fiscal year you're in is the maximum they have to pay, and then it's calculated through paren A 1 and 2. So if you just identified which CPI, you've probably got it, and you would also could say the lowest union negotiated cost of living increase for employees for that county for that fiscal year that they're in, and then you would have it.
Okay, that helps. Thank you.
sure. Okay, other comments? Julie?
Well, I have 2 if you're ready for me.
Well, Julie Kavanaugh-Bill has a comment first, if that's okay, and then we'll go to you, Jeff.
Okay with me. Mine's going to be easier, though.
Thank you, Madam Chair. On section 45, I know we discussed this at the workshop, and I know there was a suggestion to include the optional language. So either the counties under 100,000 use the case management data collection provided by the state at the state expense, or they provide the data as required by, at the time of the workshop, section 49. It looks like it's now section 47, to the department at county expense. So I thought we were going to have the alternative in there, but I don't see it in the current proposed regulations.
So, Marcy, I'm not sure if you want to address this. My recollection is that we flagged this again, but I think that we actually didn't rewrite it, and partly because we didn't have any suggested language from submitted to the department. But Marcy, do you want to comment on that?
That's correct. We had submitted this language similar language to this at the last workshop, and this is what moved forward. We did not receive any sort of public comment or any other alternate ways of writing it. So this is what we've proposed.
And Madam Chair, if I may.
Can you say that again, Julie?
Yeah, I thought we had discussed that, and just including a clause that they may use it at the state expense or provide data as required by the section at the department at county expense.
So I think that we did kick that around, but I think part of it is they didn't add it in, partly because they didn't receive any comments from anyone. But I guess this kind of comes down to a little bit to where do we put the flexibility in this provision, which is, are we creating a special opt-out which would allow them to submit data? I think I don't want to characterize, so maybe Marcy said, but I think one of the department's concern is if they don't get their data on the legal server, it's going to be difficult to use the data. And I think that there will probably be, I realize Elko County had objected to this earlier. I realized they were making a decision in the fall about case management systems. So we are anticipating that there's going to have to be some kind of ability to use the management system that they're on and connect it with legal server. But I think part of our thinking was that there's actually just some other points where that can happen other than in this regulation. So Marcy, maybe you can just explain a little bit, like where the sort of how Elko County might be able to work this.
That's correct. We did, when we put out our small business questionnaire, if we did not go forward with everyone using the same software, it would increase the cost for the department to be able to analyze the data and collect the data. So we did reflect that in our small business questionnaire that we put out. The thinking is that, like was presented by the administrative office of the courts, when individuals are using the same software, the data generally has the same meaning and is more valid than if people are allowed to put it in different ways. My understanding, and legal server is here if there's comments, is it is possible that an interface could be built between legal server and Tyler Odyssey. We have reached out to Elko County to advise them that there is this possibility of an interface, but that they would need to reach out to talk to them about developing that interface. Our understanding is that Elko County entered into a contract with Tyler to provide services to the court and to the public defender. However, the district attorney in Elko is on a different system. They are continuing to be on Justware. In reading the contract, it appears that it'll be at least a year until Tyler is available to Elko. And that was, the contract was signed sometime, I believe, in November. So it won't be until possibly 2020 that they have that service. But in the meantime, legal server will be provided to all the counties, the rural counties. The expected date is March or April for use. And if they're able to use that, we're able to start collecting the data in a uniform manner. Again, we can talk to Elko County in developing their plan to see if they would like to look into the interface by using Tyler Odyssey systems and interfacing with legal server. That's something that we've tried to open up the communication lines on, but we haven't heard anything back. And again, legal server, I believe, is here. And my understanding is they haven't heard anything either. So I am not sure what the cost of the interface would be. There needs to have that communication started. But this is something we could try and work out in the plan in the future.
This is Chris.
Go ahead, Chris.
Thank you, Madam Chairwoman. I think we've hashed this issue out at each board meeting. The reason the language is not there is we did not reach a consensus, so we went forward with what was proposed. My understanding is no additional comments were received through public hearing. And my thought is we move forward with requiring legal server. The whole point of this legislation was continuity. It was to settle a lawsuit. It was to make sure that we provided justice and indigent services. And if Elko or anybody else decided to go ahead and buy something that they knew probably wouldn't be working and went ahead with it anyway, if there is a way to get them to be able to work with legal service, then that cost should be on them and borne by them at that point, because they knowingly went forward with it. I just think it's time to get to the meat and potatoes of this and move forward.
This is Matthew Pinnell, Elko County Public Defender. Can I have a moment to speak to all that?
Yeah, please go ahead.
So this is my first meeting as the public defender. My tenure started on January 4th. So much of this is something that I didn't have previous involvement with. I'm not going to discuss essentially what I would speculate about what my predecessor or anyone else did. But I can say what the efforts that I have put in is that we did hire a new office manager because the prior office manager became the court administrator for Judge Kristen Hill, who was the public defender.
Mm-hmm.
So that person is Sharon Butterfield. She has been in contact with Justware and Tyler Odyssey to see if we can make some kind of interface happen. I guess we're running into some of the same difficulties in that regard, but we've at least tried to start that process so that we'd be able to comply when the time comes. So I don't know the particulars of why the contract was done with a service provider that wasn't something that was provided by the state and DIDS. But I know part of it was because of the pressure from the court system or the courts themselves and the district attorney's office to maintain an integrated system within our own county system. But I understand there's nothing to be done in that regard at this point in time, but I simply wanted to inform you that we are trying to make some outreach to these companies to see about an interface.
That's really helpful.
Chair Trump, may I interject?
Yeah, go ahead, Jared.
Thank you. Jared Hickman for the record. Just to kind of dovetail in with Mr. Pinnell's comments, one of the things that I think is important to point out is the statute doesn't, and I'm referring to 180.450, doesn't just talk in terms of compliance plans, but also the time in which compliance is achieved. So we have some flexibility in the statute itself to not only to work through these problems with Elko County and assist in that interface and establishing a longer timetable if needed. So there is flexibility, although it is a requirement for use of the system, there is flexibility built in terms of the time for which compliance should be achieved.
So that's all really useful, especially hearing from you, Mr. Pinnell. I think I agreed with Jared that we have some flexibility, and I guess I see it in two ways. Three ways. One is that we have sort of timing flexibility. I think each county is going to be working out their plan. So part of that plan is basically can be, how are we going to do this? What does it cost? Who's going to do it? Like, for example, can legal server get one system to talk to legal, get the other system to talk to legal servers to minimize whatever Elko County would have to do, or is more going to be needed to sort of work that in? So that's a process that I think is very individualized and can be worked out. So I think that will be helpful. But also, the regulation itself is temporary. So if at the end of the day we you're going through that process and we feel like it should be reflected in the regulations that we have, we can come back and build that flexibility into the regulation. I think our instinct now is to not build it into the regulation until we get to that point. But that is one of the beauties of having temporary regulations before we have final regulations, is that we can kind of work out some of these kinks so that we're setting up a doable operation that's not going to be in violation of a regulation. So I don't know if anyone else wants to weigh in on that or anything else.
This is Bill Moppin. I think you've summed it up very well. One, these regulations, temporary regulations, are reasonable on their face. Two, they are reasonably contemplated and consistent with the statutory mission of this organization. And finally, you can't really make a lot of mistakes at this stage because you've got a matrix that you're dropping on this problem, and you're going to get to see how it comes out, and with the best available empirical evidence. So I'm good with moving to approve the temporary regulation.
Madam Chair.
If that's a motion, I second it.
Was there, Dave Mandela, did you have another comment?
Yeah, no, I just kind of wanted to reiterate your comments as well as Justice Moppin's. I think changing it now, I think it's good the way it is. I think Elko will make a good faith effort to integrate and get the information. I think that's part of the plan, so it makes sense. So everything you said, I would agree with, and I think we need to move forward at this time. And like I said, it could very well be that it's a successful integration and everything works out, and then we can build other things into it. So.
Okay. Are we back to Laura's motion? Do you want to?
But I'm thinking I might have cut Jeff off because I think Julie went first and Jeff had a couple easy things.
Oh, yeah, right. We forgot. Sorry.
So thank you. The first one comes to us from Janelle Thomas, who is the director of our Special Public Defender's Office. And I told her that I would offer this for her. It deals with Section 21. It deals with paragraph 2. This is where a county under 100,000, and by the way, both of my things I called Marcy about yesterday, so these are not secrets. I told her what I had in mind yesterday. She just wants to make it doubly clear that this is not done on a case-by-case basis, that a county who elects to opt in does so for the entire next fiscal year. My suggestion would be in the second line there, where it says and/or direct appeals to the appellate court of competent jurisdiction, and I would insert something like for the following fiscal year, comma, then the Board of County Commissioners shall notify. Just that tiny little thing there to make it clear it's not a case-by-case basis, it's a whole year at a time. And that's about the only way Marcy could budget for it in any event, is if we do it as a whole year at a time.
True. You know, I went through the minutes and Marcy did explain that last time. I think that if it's possible without delaying anything, I think unless you disagree, Marcy, that's probably a really good suggestion.
The only thing that we would point out is that, again, this is Marcy, NRS 180 does set forth the process that counties need to follow to opt in. They are required to let us know by March 1st of the odd numbered year whether or not they're opting in or out. If they opt in pursuant to that subsection 3, they're in until this board says that they're no longer in. So it's pretty much a decision that you make, that if you make that deadline and you opt in, you cannot transfer that responsibility back to your own county unless you get prior approval of the director of the department or the department.
So let me just see if I'm understanding. Is it possible that for the following fiscal year actually is not accurate? Because once they opt in with both feet and they stay there until they're let go, right?
Okay.
That is correct. They make that March deadline and they opt in, they will be there till this board allows them to opt out.
All right.
Thank you, Marcy.
I'll withdraw the suggestion.
But you
Then-
have another one, right?
The
Another-
second one is one that I came up with. I'm in section 44. The very last sentence under paragraph 2. It says consistent with NRS. We're talking about here about the workload studies. It says consistent with the NRS, results of each study shall constitute the board's guidelines for determining maximum workloads. Well, it might be a recommendation to us, but it's not going to be the guidelines. We're not delegating the authority to them. We might actually have a public defender who comes in and wants it to be even lower. We might agree. We might even have a situation for any other reason where we might want to change the number. And the way this is written, we'd have to go back and get the vendor to agree with us to change the number. So I would strike out constitute the board's guidelines and insert it'll be a recommendation to the board in then continue with determining maximum workloads.
And Chairwoman Traum, this is Marcy from the department. We do agree with what Jeff is recommending. We had come up with in the last sentence, if you delete constitute and instead use the word inform, and then it would read the boards, and then delete guidelines for determination and change it to determination of the maximum workload. So it'd be inform the board and would be our proposal.
Read that whole sentence then, Marcy.
The sentence would read, results of each study shall inform the board's determination of the maximum workloads for attorneys providing indigent defense services.
In a way, that's still almost saying it constitutes. We just inform the board if that's what the answer is, as opposed to making it clear that the board gets to change it if they want to. I'm open to other words. I just want to make sure that, 90% of the time we're probably going to just do whatever they recommend. I get that, but I just want to make it clear that often in the future, if we want to change something, we retain the authority.
Well, this is Bill Moppin. You don't want to say that some outside source informs our decision, because as Jeff points out, that means that the outside source then is forced upon us.
So other options that our department has come up with are that it shall constitute a guide for the board's determination or shall be considered in making the board's determination. I don't know if any of that language is better.
Can we just go back to the original, like would saying that the board's determination of the maximum workload attorneys providing indigent defense services shall consider the results of the study? Just consider.
I'm fine with the word consider.
I'm not sure I got your language originally, so if I'm leaving something out, it's not intentional. I'm just.
Well, my language was striking the phrase constitute the board's guidelines and inserting in there instead be a recommendation to the board in, and then it continues determining.
Because you can't bind that works a lot better, because you can't take the board's discretion and delegate it to another entity or report or whatever you want to call it.
Yeah, I'm fine with that proposal. Marcy and Jared, are you good with that? Do you have the language that you need?
We have that language.
We haven't read it one more time.
You want to read it one more time, Jeff, so we make sure?
So I'll just start at the beginning of that sentence. It would be consistent with NRS, all those numbers. Results of each study shall be a recommendation to the board in determining maximum workloads for attorneys providing indigent defense services.
We got it.
That's it. I'm all done, Chairwoman, excuse me.
Okay. Any other comments on the regulations?
I only have one, but it's purely cosmetic. Back in 2007, when we first thought about this on the Supreme Court, and get this started. I never dreamed that we would get to the point where we would be making a motion like this. So I want to congratulate everybody that's been involved on this. This is, I have to tell you that it is on a personal level, this is extremely gratifying.
That's not really cosmetic.
Could I make a comment following this? We wouldn't be here if it was not for you, Justice Maupin. And I would also like to take a minute and just remember Bob Kroll, our mayor, and his guidance. So thank you, Justice Maupin, and we certainly wish that our Bob Kroll was here to celebrate with us. It's been a long, hard road, and you were there in the beginning, Justice Maupin.
Amen, Laura.
And a lot of others who've just put a lot of effort into this over the years. So, okay, before we do that, maybe we should move on to actually approving the regulations. So is there special language that I need to adopt here in terms of approving the regulations?
This is Chris. I think Justice Maupin made the motion and Laura System has seconded, and the motion was to adopt with those changes.
I'm sorry, just real quick, just for a clean record, this is Daglong. Just for a clean record, we're on agenda item 5, which is the public hearing. So if you can close the public hearing first, which means no further comments, and then on agenda item 6 is the adoption, and then choose a specific language instead of saying approve that you adopt.
Okay, so let's do that. Thank you, Daglong. So we are closing the public discussion of the regulations, which have been proposed, now discussed. We are moving on to number 6 on our agenda, which is adoption of the proposed temporary regulations of the Board of Indigent Defense Services. Those temporary regulations will be, if we adopt them now, they'll be good until November 1st, 2021. So we did have, am I allowed to entertain the motion that we already had from Justice Maupin, seconded by Laura Fitzsimmons, to approve the temporary regulations with the minor adjustments?
Actually, I think that our mentor, Justice Maupin, is a non-voting member. I don't know if you can make a motion. I will move to adopt the proposed temporary regulations of the Board on Indigent Defense Services as modified, as discussed on that one section, which was 44 2B.
Yes.
Laura, just for clarification, with Jeff Wells' language?
Yes.
Then I'll second that.
Thank you, Joni Easley. Okay, all in favor of adopting?
Madam Chair.
Yes.
Discussion on the motion.
Oh, go ahead.
This is Bevan Lister. So my question is, does that include ability for the director to make cosmetic changes as she sees fit?
I think so, but I think we're actually adopting them as they are. Is that? Right? I think we're not making cosmetic changes after now. Is just if there's anyone who's not on board with that, let me know so I can.
You don't make cosmetic changes at this point. What you do is you enforce them within what you think the intent of them are.
Yeah. So these are the regulations. I think the only change that we've made today is the one that was mentioned in the motion, which is on section 44, which we just discussed a few minutes ago. I think that was the only language change, and I think we're not making cosmetic changes as we have them now.
Didn't we have a language change back in 18?
Yes, you did.
It wasn't mine, but I thought we had one back there. To say current year or something for the contract and for the CPI.
I don't think we did, because I think if you look, as Jared said, in just section 1, a fiscal year must not exceed. I thought we kind of thought it was handled there.
Okay.
Yeah, I don't believe we did. Dave Mendiola.
Okay. Fair enough.
Okay, so my understanding is that we have a motion to adopt the regulations. The motion is seconded. It incorporates the language change that we did make to section 44, which we've identified a few times. Any more discussion? None? Okay. So all those in favor of the motion, please say aye.
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 Okay.
Anyone opposed? Okay, the regulations are approved, which is very exciting. So congratulations to all those who put a lot of work in it, and most recently, especially the department that has really kind of spearheaded this whole effort over many months. And so this is very exciting that we're getting on to the actual regulation of indigent defense services, which is exciting. Okay, with that, let's move to agenda item number 7, which is the update from the department. Go ahead, Marcy.
Thank you, Madam Chair. So I'm going to cover part and Jared will also cover part. Just as an update on the status of our bill draft request, as you all recall, we did submit some bill drafts for death penalty being a certain expense, which we'd like to model after what our regulations say, and also having appeals be a state expense. And we also submitted changes to Chapter 7 to clarify the appointment versus selection of counsel, the payment of expert fees, and to overall try and create independence with the judiciary. We have submitted those. We are not sure what the status is, so we are checking into what the status is exactly of those, and we are hoping that they move forward at some point. Moving on to our governor recommends budget in relation to the department. The governor recommends budget was made available this week. We've been advised that our budget hearing is going to be in front of the Joint Committee on March 1st at 8 a.m. Overall, the budget for our department has been kept pretty much status quo. Legal server is funded for the next biennium. Unfortunately, training was reduced from $35,653 to $3,166. So that number I gave you did include the IFC funds that we obtained from training. Our maximum contribution decision unit of $4,834,219 did not move forward. That's in relation to Section 18, the maximum contribution of a county. We had reached out to the counties to try and determine how much they felt they needed for the next biennium, and that's what that number is based off of. But that did not move forward in the governor recommends budget. The complex litigation unit also did not move forward. We had budgeted approximately $602,000 for year 1 and $765,000 for year 2, but that is not in the governor recommends budget. And finally, ending with my portion, the weighted caseload study that did start this week. Monday it started. It's going to go through March 5th. We did send you an update from NCSC as a result of the focus groups. So that's the first report that we've received. And apparently 44 attorneys have already signed in and started keeping time. And they're going to keep updating us as we go through about the attorneys that are participating. And then I'll turn it over to Jared for the last update.
With respect to training, 4 points to make. First is we are continuing monthly CLE opportunities. For consistency, we've moved those to the third Thursday or Friday of the month. As we stand today, we are planned through May. Last week we had a DUI basics with Chip Siegel and Joel Mann. Very good attendance, very good conversation, very good turnout. In February next month, the opportunity is Nevada Rules of Criminal Procedure, which will be taught or instructed by Judge Jim Shirley. In March, we're looking at providing the nuts and bolts of juvenile law with Gianna Verness of the Washoe County Public Defender's Office. The April opportunities will be encompassed in the virtual conference on the 22nd and 23rd, which is my second main point. So I'll discuss that there. In May, we're looking at an opportunity challenge stop and sniff, a Fourth Amendment opportunity with Professor Trom. Moving to the virtual conference, the goal here, what we will be doing is 2 days providing 10 hours of CLE. The first day will be a half day, 4 hours. 2 presentations. One is the anatomy of a case from complaint to cross-examination, and that will be taught by John Arriscata, Washoe County Public Defender, and Maria Pence, who is a public defender in Douglas County. The second 2-hour offering or opportunity will be competency, intellectual disability, and mental health with Dr. Piasecki, Mario Walther, a public defender in Lyon County, and Julia Murray, the training director from the Clark County Public Defender's Office. Third topic is we are preparing a rollout of a. Pardon me. And then on the 23rd, the second day of the virtual conference will be a 6-hour presentation, cross-examination with Larry Posner. He is an expert from Colorado that we brought in for that training, and we expect that one to be really, really entertaining and useful, and provide very useful information. Third point is the rollout of the First Friday program. Essentially, a quick description of what we're envisioning here is a kind of a quasi-mentorship opportunity. It'll be monthly brainstorming opportunities, matching issues with attorneys across the state. So if someone has a rather novel or unique issue, can present it to the essentially the group. That group will find an attorney with experience in the area, and put those two together to brainstorm issues and move the case forward. We're currently meeting with the planning committee monthly to get the essentially guardrails up in terms of the process for submission meeting. We're anticipating some student involvement from the law school, and we should have the announcement and rollout of that program forthcoming in the next couple of months. Then the final piece of it is the overall CLE and trial skills, kind of what I'm calling a master plan. Our goal here is to provide not only the content-based CLE that we've been providing over the last year, but also combine that with a trial skills curriculum that are, essentially dependent upon the experience level of the attorney. So as new attorneys come in, we can begin with a kind of a core trial skills program. After the end of the year, we'll have a curriculum developed, potentially like a boot camp. And then long-term goal are to make and provide training manuals, checklists for for attorney usage throughout the state. Currently, I'm working with Julia Murray, the Clark County training director on this project. I've had some discussions with Mr. Pinnell from Elko County, and he's very interested in working together on developing training plans, not only for the state, but his office as well. And so I think we've got a good group there in developing and implementing that.
Jared, if I may ask, when do the First Friday meetings, what time of day are you anticipating we do that? Because I'm starting our in-house training program at our office this week, and it's going to be every Friday afternoon. So I'm wondering if that coincides. That could just be part of our regular training schedule as well. But it depends on the time of day, because we have a new district court department now that is causing us to have to be in multiple places at once, more than we even had to before. So I just want to make sure there's some kind of time that I can expect to maybe integrate that into our weekly training program as well. And I just want to say, Jared, thanks for reaching. You did mention it that we've been working a little bit on developing our training materials. Actually, I had a 2-hour session with Julia Murray yesterday as well. So I think that we're on the right track to getting something developed that could be used in our office, and then hopefully, sort of exported, like you said, across the state. And so we do have our first training tomorrow. I'm glad that we're getting that off the ground, but certainly have some coherent training materials, and help from the outside would be appreciated. So,
and I think we'll have information in the upcoming week in terms of an answer to your first question. I think the time frame we're looking at is Friday, the first Friday of every month, over the lunch hour.
Oh, okay, that'll probably work for us then.
Go ahead.
Fantastic.
Go ahead, Laura.
It'll probably be a bookkeeping nightmare, but I was wondering if you guys had considered, since this is all going to be virtual, and so it's going to cost the same for 2 people as 20, if you could open the CLE to paying members of the bar. I'd much rather give my money to you guys than somebody else. And I think there are many lawyers that feel that way, but it may be one of those things that because it's a state thing, there's not an account or some bureaucracy.
Marcy, did you want to, or Jared, do you want to comment on that?
Well, at this point in time, we cannot charge at all. And I know Jason Colnut is here from our office. We don't have the authority to take money at this point in time. So that could be a process that we could look into with the board to try and set up. But at this point, we're not set up to be able to take in money. And then also our focus at this point has really been on creating a conversation with the rural attorneys and really getting them to know each other. And I think Jared pointed out that last training that we had last week, we really got some great conversation. There was a brand new attorney that was sharing how he had just passed the bar and explaining his case. And all the rural attorneys jumped in, said, call me, we will help you, reach out to us. So we're right now we're trying to focus on building that relationship, and it's really working. So that's really what our focus has been.
Drew, do you have a comment?
Yeah, just I wanted to comment. Laura, we've kind of always offered CLE and training opportunities for free. One of the things that we've learned, and the beauty of this virtual world we're in now, is that the public defender, the federal public defender, the special public defender have always had monthly get-togethers for lunchroom CLEs. But because we're now doing it virtually, and Julia Murray in the public defender's office has reached out to Marcy's group, we're now able to virtually have the entire state on the class at the same time. We just had one yesterday on forensics of substantial bodily harm with a nurse out of California that was set up through Julia's office. And I noticed online were attorneys that I wasn't familiar with. And I talked to her afterward. It was from all over the state. So I think it's been daunting having to do these virtual meetings, but what we've learned is we can bring the entire state together and, network and realize that there are other people in the state who have the same problem and can reach out, just like what you talked about happened with yours. And so just let the group know that these training opportunities now happen monthly, and it's great that it's happening.
And Drew, to follow up on that, the federal public defender, Clark County public defender, Clark County special public defender have been very forthcoming with ensuring that we've got notice of their trainings. We can provide notice to our group of attorneys. And what we have got everyone to agree to do is we've created kind of a centralized CLE calendar on our website. If you go to our website and hit the training button, that's going to take you to a calendar that has the forthcoming CLE opportunities that are provided by not only our office, but those other groups as well. So they're delineated by Nevada Federal Public Defender, Clark County Public Defender, Clark County Special Public Defender, and how to get in touch with the person presenting for registration. So all that's kind of in a centralized place.
I think that's great.
Yeah, I just wanted to make 2 points about one about the training, which is there's just a lot of energy and exchange happening with all of this training in terms of designing the curriculum, creating multiple points of entry for people of different levels to connect. So that's just one of the beautiful things that we're seeing, and it happens at the training level, at the planning level, and it happens when it actually happens. And then with this mentorship, it'll happen more, so that I think that creates that will create the cultural shift of just defender to defender knowledge and connection, and also just a sense of solidarity, because especially in the rurals, people are doing this work sometimes by themselves and can feel very isolated. So this is a wonderful way for them to know people to call at a minimum, and feel that sense of support, and also the importance of the work that they do. So I think it's exciting to see, today we're moving creating infrastructure to this work actually just happening for people and having it make a difference for the clients and the lawyers who are doing this work. So that's really great. I did have a question. I don't want to close off the discussion of the training, but I did want to go back, Marcy, to your budget report, which is just you're talking about major budgetary frustration in terms of the goal of the department. So maybe you could just say a little bit about like what your coping strategy is with moving forward with, as of this moment, kind of a no or extremely limited budget, and continuing to try to do the work that it's the mission of the office.
With the current governor recommended budget, our office will continue or be able to continue to carry out the services that we've been doing. Because we do have a reduction in training, we will have to rely on Zoom trainings and volunteer attorneys to assist us because we don't necessarily have the funding to hire an outside person to come in and train. But in talking with Jared, we believe that we'll be able to make something work for this biennium to make sure that we're able to provide the training, especially when we're working with Clark County Public Defender, the Special Public Defender, and the Federal Public Defender. Like we said, legal server is fully funded. Our budget is kept status quo. Our travel has been kept status quo, but we think we'll be able to survive with that because now knows how to use Zoom. So when we're meeting out with the counties, instead of traveling there and spending money that way, we can use Zoom and use those appropriate resources. So we will be able to proceed with what we need to do and carry out our mission is ultimately our goal.
Good.
If I could speak to that,
please.
Thank you, Marcy, on all of that. And we all recognize what we're going through on a state level, on a personal level, on a regional level, on a state level. I would suggest that the fact that the maximum contribution level did not move forward, it did not make it into the agency budget. I think at this point, we've talked in the past, some of us, and I think everybody that's on this call, this is an issue that, Marcy works for the governor. Believe me, we all know the governor's office is doing their absolute level best to make this state stay afloat and meet everybody's minimal needs. But if anybody on this call has any opportunity as the budget process moves forward, if this is not something Marcy's going to be involved with, but if we know legislators, Marcy talked about the budget hearing on March 1st. If anybody has a friend or a colleague or is a constituent of someone that's on that committee, I personally think it would be extremely important for those members to learn about the Davis settlement and learn the financial risk that we would take as a state if we actually had no money to contribute to the counties. We've promised the counties that we were going to do this. And to the extent that we're implementing county plans and it costs more, we're honor bound and legally bound to meet those financial needs. This is something out of the normal departmental, in my opinion, departmental budget process. I don't know how many departments have a sort of Damocles hanging over their heads with potentially a $10 million liability from a consent decree. So this is independent of Marcy's agenda, independent of her incredibly positive work that she's doing within limited budgets and recognizing the budget's limited. But those of us that feel we can talk to the legislators that are involved in that March 1st hearing, that's also difficult now. Everything's changed. But if somebody has some insight into how that process works and how we can help our rural counties, how we can individually and as a board help fulfill the law and our promises to them, I'd really appreciate it. I hope that wasn't out of line, but you know me. Bye.
Well, it isn't out of line.
Laura, the only thing that I would say, this is Joni, the only thing that I would disagree with you on is that Marcy doesn't have an agenda. It's the board's agenda that Marcy carries forward.
I'm sorry, I was actually looking at the agenda. You know what I mean?
Oh, got it.
Oh, yeah.
Okay.
No, she had,
Okay.
thank you, Joni, because that could have been misinterpreted. I was sloppy. Thank you.
So anyone
This
else? Go ahead.
Yeah, this is Chris. I would tend to agree with both ladies, actually. I think we have an obligation to still either during testimony at the hearing or we take a resolution of some sort from the commission. It's awkward because Marcy does work for us and we give her direction, but she's still in the Department of Administration. So she has to deal with that side of it as well. And every department's hurting right now. The state, as we all know, due to COVID, is, just got financial issues. But if you don't ask, you don't get. And I do think we have a responsibility to make sure that we at least attempt to get some funding, or at least get some language, something that helps us fulfill the needs for the rurals down the road. That's, I think, an obligation that we have.
That's useful. And I guess
to that end, I'm sorry to interrupt it, but I promise I'll button it. To that end, Chris, I believe that you were appointed by the speaker as a legislator with financial wherewithal and experience. So if you can guide us through that individually, or, I mean, obviously this is not a part of our meeting or anything else, but any of us would individually just love to have you take us to school on how best we could approach this. And I think at that point, we probably, I mean, I'm not trying to cut anybody out, but I'd forgotten, Chris, you know so much about this. You're a real resource.
I wasn't, I haven't been there in a while, but I'm happy to. I actually have a conversation with the speaker coming up next week. So yeah, we could talk about some strategy on that part of it. And I do think we should at least appear, either the chair or some members of the commission, virtually at the hearing, or send a letter in from the commission with regard to, recognizing and appreciating that at least the budget wasn't gutted, but that we have an obligation that we still feel in order to be able to make this work, to ask for that additional revenue.
And then, Chris, this is Anne. Just at the 30,000 foot level, really scaling back, the funding isn't in the proposed budget, but the department can still make a case that it should be. Is that correct, or is that not correct? And then, are there other funding opportunities? So I just wanted to, just curious.
In those days, they can still make a case, but it gets awkward, and it's awkward for an administrative department to then argue against the administrative budget. Right. So I think
that's why it's up to us.
Okay.
Right. I think it's for us rather than staff. Now they can say, they should, in their presentation, explain what they had asked for and why, so that at least the case is made as to why they asked for those dollars. And then I think us, the board, should then pick
Chris,
up the argument.
my understanding is that since it didn't make the agency budget, the committee won't even know it was asked for. And my understanding, I remember this from the prior administration. I don't know if it's changed, and it was in the context of NDOT, so I'm not saying it's global knowledge, but my understanding is the department head, when a budget issue comes up, can only answer questions on that if it differs than the governor's recommendation. So I think once again,
I don't think that's changed. I don't think that's changed, Laura. And does anybody have any idea, when is the next money committee meeting?
March 1st at 8 a.m., right?
Okay. So we've got our work cut out for us between now and March 1st.
Okay. So it can come from the board, and it can come from others, right? Which is, there's, the representations on the DIDS. The importance of the DIDS matter will come from possibly from us, but also from others. Yeah.
What we probably ought to do is make sure somebody on the finance committee asks the question, what did you not get, what you asked for that you were not able, we can talk about that strategy wise.
Can I ask Laura a question?
Yes, go ahead. Just go
ahead. You and I have talked at some length about some sort of private funding for this, for some of this. It's not, obviously not going to solve the entire problem, but it occurs to me that that between you and I, we might be able to gather a group of donors to at least pay for these various trainings around the state and help coordinate with it. But is that what you had in mind?
That's not what I have in mind at this point. Right now, I want to get through the budget process, Bill. But I think that there will be times, and I think there's absolutely, if you look at the kind of numbers that Marcy's looking at, she made reference to the max contribution formula numbers from the counties. That was almost $5 million. That's not what I had in mind.
No.
But if we can help, if we can find some donors that, are like-minded, maybe next year when COVID's done, to host a retreat or something like that, we'd love to help in that way. But this is an institutional problem. And I actually feel going forward, we all know, I don't know. I can only imagine how impossible this is for the legislature, the budget committees, the governor, everybody, department heads. But I think we do need to make a showing now, understanding and respectful about the circumstance they're in, because we are going to have interim finance requests, and then we're going to have the next biennium. And so we've got to stay, present and informative, and just keep reminding everybody, because as a new department, these people aren't used to seeing us. They're not used to seeing, not us, but Marcy and her department. And, so they've been told, I remember last time around when they were being formed, they were basically told, because we all believed it. I think I may have said it too, and I apologize. You're getting a shoestring now because you're brand new, but wait till 2021, and here we are. And it's so I think really, Chris, if we can figure out how best to follow your guidance, or anyone else that has legislative experience or connections or understands the process as individuals, I think we need to figure out how best to carry that message, because it's not something that the executive branch can carry.
Is that Joni?
Yes, it is. Thank you, Madam Chair. Maybe it would be best if we draw the legislators' attention to NRS 18320 subsection 3 that they adopted, which requires us to adopt regulations to establish a formula for determining the maximum amount that a county may be required to pay for providing indigent defense services. They adopted it. We fulfilled our part of it, and we really cannot put that subsection to work until we get some funding.
That's an excellent point. I think if we decide as individuals and people that are committed to this issue, if we decide to testify, I think we need to get pretty much figured out who would say what. And I think that would be an important point. I think I've been involved, we all have, in bills where it hasn't been this much of a pressure cooker. And if we just decide who best from our board, which individuals on this call, which will include providers and a lot of other people that aren't on the board, feel they have some point, like Joni. I think, Joni, I'd love it if you said that. But I think that's kind of an off-deck conversation. And Chris, if you, I think I still have your cell number, but if we could just set up something, because, March 1st will be here before we know it.
Absolutely, and I'm happy to help in any way. I would also say, Marcy, can you get for me, there used to be standard language that we adopted for folks to be able to take private donations. So aside from this issue, it was gift language. There was a budget line item that allowed for a department to accept gifts, and there was some standard language that's there. I think at a minimum for future, if things such as Justice Maupin or what you're talking about, Laura, for other things, they should at least still have that ability, and right now they don't. So that's just something as an aside that we don't want to forget to ask for.
This is a joke, but in a sense, but Christie and I, we're always on the opposite side of legislative issues. So maybe we should bond that synergy together and use it for the good of this group.
Works for me.
All right.
Madam Chair, in response to Chris's comment, we did submit language to be able to take in donations in our bill draft requests. So hopefully that will move forward so we can start doing that.
Okay.
We don't want that to be our primary source of funding, though.
Believe
No,
me,
never.
I might be buying a round of drinks. That's about it.
Laura.
Well, I'll buy the second round, so because it won't cost as much.
Okay, well, thank you for that update. Any more comments on the department's update? Okay, lots of work to do in terms of helping the department survive and do the work that needs to be done. Okay, let's go to number 8, which is the discussion and confirmation of meetings. Partly the long list of rescheduling is partly my fault because I teach on Thursdays, which is a meeting day. So I rescheduled for today, but we're moving meetings to Wednesdays. So that's the explanation. I apologize for the inconvenience, but here's the slate of meetings through June, which I think are on Wednesdays, and then after June through the end of the year, which I believe are on Thursdays. Is that correct, Marcy? That the second half, they're all on Thursdays, right? No?
They continue on Wednesdays.
Okay, good. Great. Always on Wednesdays. Slate through the end of the year. So we know that people appreciate having these meetings on their calendar well in advance, and we just wanted to make sure that everyone has them. So I don't think, do we need to approve those? I don't think so.
No.
Sure.
No.
Okay. So, and then we can, is this a request for items for future agendas?
If there's any items that the board would like us to add to next month's agenda, we're just reaching out to ask that.
Okay. I actually personally would like a little bit of guidance from Dag Long, possibly on the extent to which conversations about the board activities can happen not in an open meeting. So I realize we've been warned before about serial meetings. So I don't know if you have anything to say on that, Dag Long.
Sure, I can do that. It will be very short. There's very little exceptions to that, so it'll be a short agenda item then.
Oh no, I mean, like, you could give that advice now, like, in just saying a little bit about that. Like, are we restricted in terms of talking to each other?
No. Well, again, pretty much because I think I discussed a serial quorum, and so we're always at risk of that happening.
Okay.
So anything that's under your purview of the board, I just wouldn't talk about it outside of a meeting.
Do you think that like, if I'm just hypothetically, because the open meeting law has always been a mystery and it's always reinterpreted, and I appreciate the fact that the current administration is really protecting us in favor of transparency. That being said, I don't view any conversations about individuals going to the legislature on funding as a board issue, because we'll never act on it. We will never vote on that issue. Am I wrong?
No, you're not.
You're not wrong, but that's only coming from someone who's written some opinions on this. And we've done nothing but confuse the issue. My view is that the open meeting law isn't that strident when it comes to individual communications between two board members.
We decided to go out to dinner and we're talking about the restaurant, and we weren't going to do any board issue. We weren't going to talk about something on our agenda that we're voting on. It seems to me like the same thing as preparing for the March 1st meeting, because we have no ability, any collaboration we would do doesn't result in a uniform decision on our part, yay or nay or modified.
Right. Right, and also you could have a discussion after dinner about what you think brand new lawyers ought to know before they go into court. That doesn't violate the open meeting law. And so, I mean, it isn't an aid of taking some action. It's talking about the philosophy of the project. So,
But I guess I should defer to our lawyer.
well, I don't think we're saying anything inconsistent with what she's saying. It's just that she has to take the most conservative line in advising us, and that's certainly appropriate.
And just to be clear, I guess I'm not.
Go ahead.
I was just saying, I'm not preventing you or discouraging you from talking to other board members. I mean, I think you said something about going to dinner. I mean, that's, that's fine.
Okay.
We can even this is Chris. We can even have a discussion, couple, 2, 3 of us, but not violate quorum in some way, about a strategy for the hearing we were just discussing. I think, I mean, I'm a supporter of the open meeting law. I think it's been over-interpreted in many cases, and then others just choose to ignore it.
Amen.
But the reality is we can all be advised. I could be briefed as a county commissioner with all of us in one room, as long as we're not debating the issue, we're not taking a position, but we could all be briefed. But people overturn, oh no, you have to only meet in 3. Bullshit. But, okay, so you can have conversations but you can't violate the quorum component.
And again, Madam Chair, I would just suggest if you want to continue the discussion, to put it on the next agenda then.
Yeah, that little bit of advice is very useful, and yeah, we can put it on the next agenda, although I'm not sure we need to. That was very helpful. Okay. We are done with our agenda. It's now time for public comment. We're welcome to hear from anyone who's on the meeting to share a comment. I think people can email us during the meeting. I doubt that we've received any comments during the meeting, but if so, let me know. Anyone?
Madam Chair, I have one comment, and it's for Marcy.
Go ahead.
Hey, Marcy, I think it would be very helpful for county managers to have a copy of the focus group summary, because there are things contained in that summary that counties can begin to address immediately, such as the lack of privacy between a public defender and his client.
Great suggestion.
And we can follow up with that.
Thank you. Anyone else? Okay, we can go to agenda item number 10, which is adjournment. Anyone want to make the move?
I'll move to adjourn. But I also would, Madam Chair, I'd like to give you my phone number to have us discuss an issue that's not related to this.
Oh, sure. Sure.
So it's 702.
You're giving it to the world? Okay.
Everybody's in this room has got it.
Okay.
Well, it is a public meeting, so if anybody wants the minutes, your phone number will be on there. If anybody requests a recording, your phone number will be on there.
Okay.
We have your cell phone. We can provide it to the chair.
Yeah, that's good. Are you comfortable with that? Okay.
I'll just send an email to Marcy that has the phone number, and she can give it to you. Sorry. I'm still, that's just goes to show you how old school a bunch of us still are.
And also, right before we adjourn, can I just thank Patrick, Jared, and Marcy? Just thank them from the bottom of my heart. You guys are doing an unbelievable job.
And under the most egregious of circumstances.
Yes. Here. Really phenomenal work, and it's really just exciting to see it take shape in these new ways. So it's really exciting.
Thank you, but we couldn't have done it without all of you. So just remember that.
All righty.
Okay.
Goodbye, everybody.
I move we
Wait,
adjourn.
do we actually approve the motion to adjourn? I'm not sure we did.
No, there
You
was
can just
discussion.
adjourn. You don't need a motion.
Excellent.
Yay. Bye,
Bye.
everybody.
Bye, everybody. Thank you,
Bye.
everyone.
Thank you.